Hello, everyone, and welcome. I believe we have now started our very exciting seminar, European Court of Human Rights Climate Justice Judgments. Where do we go from here? We've got your attention for an hour. Thank you very much indeed for joining us. We have a very distinguished panel of speakers who I will introduce very briefly, and then we will move on to hear from them. And the way that we structured the webinar, which we thought might be useful given the limited time that we have available, is by way of a discussion rather than a presentation. If you have any questions, please do put them in the Q&A section, and we will hopefully have some time at the end to answer as many as we can. This event is being live streamed and it's also being recorded, and the recording will be uploaded to our YouTube channel and the link will be sent to all of those attending. So without further ado, what will we be covering today? This webinar will look at the European Court of Human Rights landmark judgments in 2 of the 3 recent climate justice cases, which were delivered by the European Court on the 9th of April. The 2 cases in which I am delighted to say that Garden Court colleagues were instructed in are that of Klima Sinironian and Switzerland and Duarte Agostino. Marc Willers, Paul Clark and Richard Harvey represented the applicants in those 2 cases. And we're also joined by Dr. Yusra Suedi, who is a lecturer in international law at the University of Manchester, who I'm delighted to welcome as one of our panelists. The rulings, as we will hear, have paved the way, or have they, will be subject to discussion, for subsequent judgments which could and will address the responsibility of states under the European Convention of Human Rights to prevent future climate-related harms. What I will do now is attempt to summarize the very impressive biographies of the panelists who are with us today. The first of which is Mr. Marc Willers, King's Counsel, a barrister at Garden Court Chambers. Marc Willers is also a barrister of the, is also called to the Irish Bar. He specialises in planning and environmental law, public and administrative law, civil liberties, human rights and discrimination, and gypsy, traveller and Roman law. Marc regularly acts for non-governmental organisations and campaigns and challenges to environmental legislation, policy and decisions relating to development, which has an impact on the environment. Marc was instructed as one of the advocates representing the applicants in the Swiss Senior Women's Climate Change, Klima Sinironian in Switzerland, which is the first ever climate change case to be heard by the Grand Chamber of the European Court of Human Rights. Second, and also instructed in the same case, is Mr. Richard Harvey, a barrister at Garden Court Chambers and also a lawyer at Greenpeace International Legal Unit. He advises campaigns principally on issues related to climate justice, including strategic litigation aimed at holding governments and corporations to account for violating the right to a healthy environment. He is a barrister who's practiced at the New York Bar, was lead counsel to the International Criminal Tribunal for the former Yugoslavia, and throughout his career, he has focused on major human rights litigation, environmental justice, domestic and international criminal law, and post-conflict resolution. Third, I'm delighted to join Mr. Paul Clark, who is a barrister at Garden Court Chambers. He has an established practice in the fields of climate justice, as well as in international and domestic human rights law. He acts for the applicants in the second of the cases that we will be discussing today, the groundbreaking case of Duarte Agostino and 32 other states before the European Court of Human Rights, and having appeared before the International Court of Justice and several of the international criminal tribunals, he has expertise in general international law that forms a key part of his practice in climate justice. Last but by no means least, we are joined by Dr. Yusra Suedi, who is the Assistant Professor in International Law at the University of Manchester. Her research is focused on international dispute settlement, climate, environmental law, and human rights. She holds a doctorate in public international law from the University of Geneva for her manuscript titled The Individual in the Law and Practice of the International Court of Justice. Yusra has worked for the United Nations Office in Geneva, the International Law Commission, the Institut du Droit International, the International Labour Organization Administrative Tribunal, and the International Court of Justice. She also has acted for governments and organizations before the International Courts of Justice. So, our very distinguished panel of speakers, very, very welcome to you. Can I just kick us off, firstly, by asking in particular Marc and then Richard to introduce us to the Klima Sinirionen case, to tell us a little bit about the clients, the complaint, what remedies the applicants sought, and then to talk about the summary of the decision, if it's possible to do it justice in the limited time available. So over to you, Marc and Richard.
Thank you very much, Irena, and I'm delighted to be able to talk about this case, this monumentous case. Groundbreaking is perhaps an understatement. I was lucky enough, together with Richard and other lawyers at Greenpeace International, another lawyer at Matrix Chambers, Jessica Seymour KC, and a team of brilliant Swiss lawyers to be able to represent the 2,000 odd elderly women with an average age of about 73, inspirational women who campaigned throughout the legal proceedings that they took first in the Swiss courts and then to the European Court of Human Rights when the Swiss courts dismissed their claim out of hand. They challenged the Swiss government for its failure to tackle climate change by adopting appropriate carbon budgets, even assessing what carbon budget it had left to use, and by doing so, failing really to comply with their obligations under the Paris Agreement. And they argued that this failure breached their rights under Article 2 of the European Convention on Human Rights, the right to life, and Article 8, the right to respect for one's physical integrity and well-being. They also argued that the Swiss court's decision to dismiss their claim out of hand was a breach of their right to a fair trial under Article 6 of the Convention. And so their case was fast-tracked, as was the Agostino case, which Paul will tell you more about. And it ended up being the first case heard by the European Court of Human Rights on climate justice. Not the first case which had an environmental context, I should add, and indeed the European Court of Human Rights specifically laid out their jurisprudence on environmental justice claims in the judgment in quite some detail. Having done so, the court concluded that, in fact, although it was of importance, there ought to be a different approach taken in the instance of climate justice, where a challenge was brought against a state for failing to tackle climate change, and crafted or tailored a bespoke approach for such cases. They then applied that approach to the case brought by the Klima Sinirionen organization and for individual applicants from that organization. And they concluded that the organization, the Klima Sinirionen, should have victim status, and that their case then ultimately, having assessed the facts, was determined to be successful. They adjudicated that there had been a breach of the Article 8 rights of the members of the association, and also a breach of their right to a fair trial under Article 6 of the Convention. What the court did then was, in effect, make that declaration. There'd been no claim for compensation. There had been a request that the court set out general measures that the state should take in order to put its house in order. But the court's judgment itself, I think, does that job by indicating what each and every member state of the Council of Europe needs to do in order to ensure that its citizens are protected from dangerous climate change. And that includes assessing what carbon budget there is that it can use up in accordance with the Paris Agreement, and then adopting and implementing policies and provisions and measures which will ensure that targets are met. So in essence, that's a summary of the decision. As you might imagine, we were delighted to receive that judgment. And now, as everyone else is, we're looking at the implications of it and how we might best use it in the future. And you know, it didn't give us everything we wanted, but it gave us a lot more than many of us could have hoped for.
That's absolutely fascinating. Thank you very much for that, Marc. Richard, can I invite you to come in with your reflections about the case?
Thank you for a lovely introduction, an excellent summary of the case, Marc. I have been an in-house lawyer with Greenpeace now, with Greenpeace International for 10 years. And it's a lot longer than that since I ever put a wig on my head. But my history of the Garden Court goes back a long time, and I couldn't be more delighted than to be here today with over 100 participants in today's session. The Klimaseniorinnen are an extraordinary group of people, as they listened to the Urgenda judgment in 2015, the first Urgenda case in the district court. About 25 of them sat down around coffee and thought, well, can't we do something like that here? And this is one of the fascinating aspects of working for Greenpeace. You don't go out and look for the clients come to you. And they come to you not just as individuals usually, but what we call movement lawyering. A movement gathers ahead of steam and they say, can we find someone to give us legal advice here? And they came to Greenpeace International and they came to Greenpeace Switzerland. And we've been working with them solidly since 2016, when this case was first launched in an administrative court, then went up to an appeals court, and then went to the Supreme Court of the Swiss Federation, where they were treated appallingly. The court effectively saying that we haven't reached 2 degrees yet, come back when we get there. In other words, come back when you're dead. It was such a shocking dismissal of their right of access to justice that very rightly the European Court slammed Switzerland for its treatment of the Klimaseniorinnen. They grew over the space of time from 25 to 2,500. And they have had an enormous impact far beyond their numbers and far beyond their original expectations, I know. We never expected that we would actually get an oral hearing before the Grand Chamber. We thought this would all be done on the papers. And so this is one of the extraordinary achievements of the case, because climate change is the game changer at the European Court. I just want to read one short section of the judgment at paragraph 497. there's been an evolution in contemporary society as regards recognition of the importance of associations to litigate issues of climate change on behalf of affected persons. Indeed, climate change litigation often involves complex issues of law and fact, requiring significant financial and logistical resources and coordination, and the outcome of a dispute will inevitably affect the position of many individuals. Up until this point, the court had said to any NGO trying to bring a case, this is it's basically a class action lawsuit that you're bringing. We don't do class actions. We need individual applicants who can demonstrate that they have been personally damaged by your government's conduct. And this complete turnaround by the court doesn't open the door to every single NGO for every single purpose, but recognizes that climate change is almost unique in that sense. And therefore giving the association legal status, but imposing still a very strict test for the individuals, gave us a decision quite the reverse of what we thought we were going to get. We thought the individuals would win, but we knew we would have problems with this association. So it was the right decision from that point of view. They also recognized that what are called scope 3 emissions, that's extraterritorial impacts, although they were very cautious about that at this stage, but what referred to as embedded emissions, because Switzerland is not a great greenhouse gas emitter, but from what they import and from how they distribute their financing, they cause greenhouse gas emissions on a scale far outside what is proportionate. The violations of Articles 8 and 6, Paul has already gone into in detail, and they therefore decided they didn't need to get into the right to life or to an effective remedy under Articles 2 and 13. And what they did very clearly was say that there is now a new legal test on states' obligations in relation to climate change. And they held that climate change is a common concern of humankind, that intergenerational burden sharing has to be part of a state's approach. And they set targets and timelines or they said that states must set targets and timelines for achieving carbon neutrality, and they must look to their own fair share of the carbon budget. So this is just a huge step forward. Doesn't give everybody all the answers they were looking for, as I'm sure Paul is going to go on and tell us in a bit more detail. Over.
Richard, that's so interesting and very hard for me to refrain from asking more question at this stage, but I'm going to go to Paul and ask you to give us your reflections on the Duarte case. Over to you, Paul.
Thank you. So just very briefly, by way of introduction of the case, I'm not going to presume knowledge of it. It was a case which was brought by a group of Portuguese young people who had witnessed devastating forest fires and experienced ever worsening heat waves in the area where they lived. And on the 3rd of September 2020, they launched what was really an unprecedented case against over 30 states. Essentially, they were submitting that Portugal was already experiencing a range of climate change impacts, including increase in mean temperatures and extreme heat, and that was a driver of the wildfires they'd seen. And they relied on various of the convention articles, and as well as a number of other international instruments, including the Paris Agreement and the UN Convention on the Rights of the Child. And a key part of their case was that the risk they were currently exposed to was going to increase significantly over the course of their lifetimes. And so there are different aspects of the age of the applicants which are relevant in both cases. And it's that contrast, I think, which helps to draw out what's at stake. What was motivating the case, and often what's asked, is why against so many states? And well, it's at its core, it was because what is necessary is collective consistency between states with the reductions targets. Obviously, if different states have different and conflicting and self-serving approaches to burden sharing, then no matter how definable a particular target might be, it's not going to be met if nobody agrees on how much work they should do. So the idea behind the case was to indicate that breach requires, avoiding breach, I should say, requires collective consistency between as many states as really can be put before a court. And what was difficult about that really was that if you take, for example, Article 2 of the Paris Agreement, the concept of collective but divided responsibilities in Article 2 of the Paris Agreement is entirely contested, and there isn't any globally agreed approach to burden sharing. So the idea was that the breach would arise from the fact that the states were not collectively consistent with the targets. Now, what the court found was not a response to any of those arguments, but rather that on two of the admissibility requirements, that being jurisdiction and the requirement to exhaust domestic remedies, that because the applicants had gone directly to the Strasbourg court without exhausting remedies in Portugal, that they hadn't exhausted domestic remedies. Now, very closely linked to that was the finding on jurisdiction. Whilst the court found jurisdiction in relation to Portugal itself, it rejected the submissions that we made as to the extraterritorial jurisdiction of every one of the other states. And it was for that reason that the focus then became on remedies in Portugal. The two things taken together were the reason why the applicants went straight to Strasbourg, alongside a whole load of other considerations, including the urgency of the issue, the obvious practical difficulties in seeking to secure remedies across all of the states, and a number of other things. I mean, I'll come on to this in discussion if we have time, but it's fair to say, I think, that the court didn't engage in any meaningful way with many of our arguments on exhaustion of domestic remedies. So that's the summary, really. We have findings on extraterritorial jurisdiction and exhaustion of domestic remedies, which were a bar to the case going forward. So I'm going to pause there because the rest of what I would say is to do with the implications of the two cases together. And I'll hand back over. Thank you.
Thank you very much, Paul. Really interesting to hear about how the court approached as opposed to how the case was put to them. Yusra, can I invite you to come in with any comments that you may have as to the summary of the cases before we move the discussion over to the implications of these judgments?
Thanks so much, Irena, and thank you to everyone for inviting me in this conversation. I think, and it's probably something that will have come up a little bit later, but I think the essence, or one of the essential things to take away from these cases is understanding who we have brought these cases to, and really understanding that courts understanding what courts are capable of doing and what they're not capable of doing, essentially. And that is critical because, and I think it's difficult to grapple with when we're dealing with, these public interest type cases of large scale, dealing with something as critical as the climate emergency. And so it raises a lot of, expectation, and there was campaigning around a lot of these cases, which was excellently done. And I think that a lot of these procedural limitations or limitations related to jurisdiction, admissibility, they really show kind of the constraints of the institutions that we're working with. And that's really important in a discussion that we're having about, where we're going from here. And we'll get to talk about that a little bit more. But just understanding how to kind of balance, and I think the court did a good job at this in this case, but also how litigants and future litigants can kind of create a balance of expectations and understanding essentially where the line might be between, or where the right balance might be between their aspirations in terms of pushing forward the substantive law more significantly and gaining more clarity and more seriousness about states' obligations with regards to climate change, and the constraints that they're dealing with, things such as, you know, extraterritoriality, admissibility requirements of victim status, things that might be difficult to understand, but in this case, I think it was really highlighted how important those aspects are.
No, that's a very good point and really interesting to think about the role of the court, which the court did address in its judgment right at the outset. And this leads us very nicely, thank you, Yusra, to the next topic, which I know we're all here to keen to learn about, which is the implication. And can I turn to you, Marc, the implication of all of these judgments? And before I do that, I've just picked up a question actually from the Q&A section. Somebody has specifically asked if there are any reflections on the implications on corporate climate change litigation, which is of course adding a different spin. So Marc, over to you.
Yeah, perhaps I could just follow up something that Yusra was saying about the limitations that the court was acting under. I mean, it went to great lengths to explain that it is a subsidiary court, it's a supranational court, and it must pay due regard to, and indeed give states generally a wide margin of appreciation when it comes to the measures that must be taken in order to tackle climate change. It tailored and indeed narrowed the margin of appreciation when it comes to the positive obligation that it concluded states have to tackle climate change and comply with their commitments, particularly international commitments made under the Paris Agreement. And in essence, what you could conclude is that all the European Court has done is hold Switzerland to the commitments it made under the Paris Agreement. It's failing clearly on the facts to do what is required. And that's the essence of this judgment. And so we're going to look at as it were, the criticism of the judgment in the right-wing press, I think, perhaps at the end of this seminar, I hope. But that, you know, that conclusion that it reached is really difficult, I would suggest, to undermine in those circumstances and on those facts. And indeed, in circumstances where the science was agreed, the facts were agreed. Switzerland agreed that senior women, elderly women, were more likely to be affected by intense heat waves in Switzerland than any other part of the population, because it was their own evidence of the increased mortality amongst elderly women that we relied upon and put before the court. So there was a political consensus too that the Swiss government had signed up to. And so all those elements put together really, I would suggest, led the court to the unerring conclusion that Switzerland had breached the rights of the Swiss women in this case. And so, you know, one can see that why and how it came to that conclusion. Thinking about the implications then, well, the reality is that none of the member states of the Council of Europe are doing as much as they should be doing to tackle climate change. So it seems to me that this judgment can be used as a template for domestic proceedings throughout Europe. And indeed, Paul's case, the Agostino case, was attempting to tackle the failure of 32 member states in one foul swoop, as it were, before the European Court of Human Rights. And I'm sorry it didn't succeed. But the reality is that I think the Swiss judgment itself can now be used by youth and other generations in each and every domestic court to achieve that goal, albeit in a piecemeal way, and not perhaps quite so quickly as one would have hoped. And given that we're in a climate crisis, I'm disappointed that the European Court of Human Rights didn't take the opportunity to expand its views on extraterritoriality as it was persuaded or suggested it should. As far as corporate climate litigation is concerned, it seems to me that every court in every country in the Council of Europe area and indeed beyond is going to have to take notice of this judgment and consider, bearing in mind that each court will have a duty of its own to comply with the convention, how this judgment impacts on that litigation and indeed on the activities of corporate bodies, both in Europe and beyond. And I think that the decision itself will not just have an impact in the Council of Europe countries, but will also influence decision-making around the globe, and no doubt have an impact on the forthcoming advisory opinion of the ICJ and that of the Inter-American Court of Human Rights. There is, as I'm sure Paul will tell you, now a marked distinction between the way in which the European Court of Human Rights has addressed extraterritoriality and indeed the way that the United Nations Committee on the Rights of the Child have approached the issue, and the Inter-American Court of Human Rights. And so I'm hoping that perhaps we will come back to this issue before the Strasbourg court in the future. Possibly Paul will be there at the helm, driving home the point that the European Court of Human Rights may in the future be an outlier and will need to think again about extraterritoriality. But I think there are many other implications, and everybody is talking about the case, and I'm sure that some ingenious lawyers will come up with some implications or ramifications that I couldn't even envisage.
Thank you very much, Mark. That's absolutely fascinating to hear about your reflections on the implications. Richard, can I turn to you? The same question really from both cases, just looking at the legal landscape.
Sure. Well, we are Greenpeace is on its way to the court with exactly this question of extraterritoriality, because waiting in the wings for a couple of years is the case of Greenpeace Nordic, Nature and Youth, and 6 individual applicants challenging Norway's licensing of further exploration for more oil and gas than the planet can ever afford to burn, which is driven purely by greed and not by need. So we have been again through the whole process of the Norwegian court system. Again, another case I've been working on for almost 10 years. We have a second case which we launched just last year when Norway started licensing the extraction of previously untapped oil and gas resources without conducting a proper strategic environmental impact assessment or updating a very old one that they had from the past in the light of currently available science. So we won this last one in the district court, and the government was, of course, appealing that. But the long-standing one that was put on hold by the Grand Chamber said, well, the Grand Chamber said, let's listen to Klimaseniorinen first and Duarte Agostinho first, and then we'll come back to you on the Norwegian case. So that's the other shoe is waiting to drop from the Norwegian case. And there are just a couple of points I'd like to make on that. One is that the issues that are now coming from the right-wing press and from certain judicial sources who are not complete strangers to being quoted in the right-wing press is completely seeking to distort the effect and purpose of the judgment. The judgment says explicitly that judicial intervention, including by this court, cannot replace or provide any substitute for the action which must be taken by legislative and executive branches of government. However, democracy cannot be reduced to the will of the majority of the electorate, and elected representatives in disregard of the requirements of the rule of law. The remit of domestic courts and this court is therefore complementary to those democratic processes. The task of the judiciary is to ensure the necessary oversight of compliance with legal requirements. It's not normally that a statement that you would expect Jonathan Sumption to take exception to, or for that matter, Tim Icke. But neither of them, it seems, is happy with a judgment that ought indeed to make anybody who believes in the balance of powers extremely happy. So I'll pause there, but on our way to Norway, we've got other cases that are going on in Spain, in the Netherlands, and of course there are the cases where we're dealing with Shell, and Shell is trying to sue Greenpeace. Yeah, bring it on. Okay, over.
Oh, wonderful enthusiasm. Thank you, Richard. Thank you so much for that. Paul, would you like to share your views on the implications of these judgments, please?
Certainly, yes. I just want to highlight a few very simple, basic things, which I think are of immeasurable importance in terms of particularly what's come from the Klimas and Irena case, but also I'm going to come back to this question of jurisdiction. So really, the three things I'm going to highlight are, first of all, to do with the 1.5 degree target. The second is the practical use of the cases in the future in terms of sources of evidence. And I'm going to come to the question of extraterritoriality. So first of all, in relation to the target, I think the clarity of the emphasis in the Klimas and Irena case on the 1.5 degrees climate increase limit, and it's the court's willingness to be prescriptive in its at least attempted definition of a 1.5 degree compatible obligation is very new for climate litigation across the world. And coupled with that, and I think this is of particular importance in the context of the way that doctrines in the ECHR become applicable to the way that states behave within their own borders. The highlight on the reduced margin of appreciation in the context of climate targets. And this is important because the two things are very closely linked. The point the court is emphasizing is that regardless of what the state may or may not claim is the appropriate approach within its borders, its margin of appreciation can't seriously take issue with the requirement of meeting the 1.5 degree target. And that has real ramifications, I think, on the way that arguments are formulated in the domestic courts, because in the context of previous decisions in domestic litigation across the world, there's been an unwillingness to set targets, and it's been a bit of a fudge in some ways. Procedural considerations, such as separation of powers, such as questions around causation, and a number of other prerequisites to courts' jurisdiction have been used to prevent or to allow courts to escape making any findings in relation to whether or not a state is meeting its obligations. Now that's been narrowed down because the court has said clearly that that states have a narrowed margin of appreciation, and it's highly prescriptive in relation to 1.5. So it's not a full answer in any domestic courts, but it takes litigants a great deal further in any given case in the domestic courts. That's the first thing. The second thing is just a quick observation, and it's to do with evidence and how the basis for the cases can be used in the future. And it's simply this, that particularly in Duarte Agostinho, the submissions of respondent states, all contending that they have effective remedies for inadequate mitigation policies, should be an incredibly useful tool methodologically for litigants within those states going forward. In many situations, these are the first times that the states concerned have been required to set out their stall quite so clearly and have it put to the test. So the result, leaving aside the fact that the case was decided on the basis of these prior requirements of jurisdiction and exhaustion of domestic remedies. There should be some real use in the submissions that we prepared and also the evidence that it was based on in terms of identifying exactly where the inadequacies are in particular states' climate policies. And the last thing I just want to comment on is this question of territoriality. Now, I've already indicated how the court found in Duarte Agostinho against the notion of extraterritorial jurisdiction. I'm going to come back to that. But a very, very important element, and Richard's already touched on this, that I really want to highlight it because of how groundbreaking it is. In the Klima Signorin case, and in paragraph 280 is a key paragraph among others, you'll find for the first time an extension of states' obligations to their non-territorial emissions. This is incredibly significant. It's been a preposterous barrier to proper accountability up to date, that the way in which states count the emissions that they're responsible for take absolutely no account of emissions which end up either being emitted, being emitted as a result of their internal actions, but overseas. This is what's generally referred to as exported emissions. There are a number of different categories of them, but I just really want to emphasize strongly that even if that was the only thing to come from these cases, and it certainly is not, but that by itself would be an enormous victory and a game changer in terms of domestic litigation. So I've been talking for quite a while there. If I may, I'll just say a brief few things about jurisdiction and some other aspects of non-territoriality. Thank you. So I've already indicated that the court found against us on extraterritorial jurisdiction. I'm not going to go into all of the detailed ins and outs of our arguments on that, but there is a multifaceted approach to this. The court found that the fact of a state having control over emissions or the effects of emissions outside of its borders was not enough. It found that there was a certain causal relationship between a state and private actors in terms of the climate effects, but didn't find that that was enough. And the fact that climate change is an existential threat also didn't find to be a basis for constructing any kind of novel basis for jurisdiction. Now, as I say, I'm not going to go through all of the factors, but it's worth noting that many of the bases on which we submitted there should be a finding of jurisdiction were in fact not new at all. There's a great number of cases in the European Court of Human Rights where extraterritorial jurisdiction is implicitly found without the court ever actually saying it. So where things happen outside of a state's borders, nobody raises the argument about jurisdiction, but because jurisdiction is the threshold requirement for the court even to make a decision for the case to be admissible, it has to be understood that the court has made a finding of extraterritorial jurisdiction in those cases. Now, it's interesting that the court was absolutely silent on attempting to distinguish those cases from the circumstances that we said were applicable in our case and similar in those. But they're things like the foreseeability of the extraterritorial effect, the knowledge of the likely impact of states' decisions within their own borders, and perhaps even more importantly, the unique capacity of states to impact upon that emission, in particular by imposing emissions reductions, imposing mitigations. So I think what the real takeaway from the court's reasoning on the extraterritorial jurisdiction aspect of the Duarte Agostinho cases is reflected, I think, in one sentence, and it reveals the teleological nature of its motivation there. And it's this, and it's in paragraph 208, that the effect of accepting our arguments in extraterritorial jurisdiction would turn the convention into a global climate change treaty. Now, so what, you might think, given the existential nature of the threat that we found, what's the problem? But essentially what you have there is admission that this is really about the court being concerned about its workload. And I would perhaps suggest that little else. On the other side of the coin, and this is the positive that I want to draw in relation to extraterritoriality, the court made a finding that all contracting states must align their targets with the same temperature limit. And this is paragraph 202. I'm not going to read out the whole section just to save you some time, but it is worth a read. But what you get from that is that the finding that all contracting states must align their targets with the same temperature limit, and that being a partial basis for the finding against extraterritorial obligations, the court found, perhaps thinking about its own guilt, that this would create no vacuum of protection. Now that's important because inversely, what the court is saying there is that there can't be a vacuum of protection arising from the absence of recognition of the extraterritorial effect that a given set of states' actions can have. It's an implicit recognition of this need for consistency across states in order to ensure that rights are protected. So while they reject extraterritorial jurisdiction for the purposes of their own decision-making, you have a clear recognition there that it would potentially be a breach if a state's reasoning would give rise to a vacuum of protection, such as because of inconsistency between different approaches to burden sharing. So I think there is some positive, there are some positives to be drawn from the approach taken to extraterritoriality, although you really do have to go looking for it. Thank you.
Thank you very much, Paul. That's really instructive. We have limited time available. Yusra, can I turn to you? Please feel free to share your thoughts about the implications of these judgments.
Yeah, thanks so much. So I had a little peek at some of the questions, and I think I'll maybe take advantage because my answer does link to a couple that were asked. So I would say that there are two significant implications for me that I'd want to touch upon. The first one is this this idea of actio popularis, public interest litigation, which the court spoke extensively about. So in rejecting that that there was victimhood for the individuals, I think that was very standard. Its jurisprudence has said for a very long time that it does not accept actio popularis, that there has to be a direct and strong connection. And in paragraphs 487, 488, and onwards, 533, 535, you can read essentially why it did not consider that in the Klima case, this was the case for the elderly ladies. And Marc touched upon this earlier. And the reasoning, I do get it, that, you know, there's this idea that we want to resist being strategically instrumentalized for a very broad, abstract kind of cases that would relate more to like domestic law or policy. And that we want this individualistic approach to human rights. I think that when we're talking about the environment or climate human rights nexus, you can't really avoid the public interest aspects of those cases anyway, right? Like environmental cases will have public interest effects. You know, every human rights case is in the public interest because the general aim of the European Convention is to serve the public. So you can't avoid it, but I do understand the court's kind of very strict approach to actio popularis. But now with respect to associations, and Marc mentioned this earlier, you know, they now have standing even if those whom they represent don't meet the strict victim status criteria. And this is huge because the bar is actually really low. I was quite surprised to read this. So in paragraph 502, essentially the association just has to, you know, be lawfully established in their jurisdiction, set up to pursue aims, including the defense of human rights of their members from the threat of climate change, and show that they represent affected individuals who are subject to specific threats or adverse effects of climate change on their lives, wealth, health, or well-being. So previously, the court had always been a bit more strict when it comes to associations. Valentin Camponeau, that case is kind of like the signature case that indicated that the threshold for vulnerability has to be really high, and it's in very exceptional cases. And now, you know, this is a very innovative aspect of the judgment. So I understand the surprise of my co-panelists in that respect. That I think the court had to strike this balance that we're talking about, right? That I think it would have been political suicide if the court had rejected all three cases on the basis of, you know, issues of jurisdiction admissibility, and that something had to give. That's my impression, and I think that this was it. And so, you know, even though the court insisted in its judgment that this is not actio popularis, this is not a public interest litigation, you know, we don't accept that. I actually think that this is what it has said about associations and now the rights that they do have. this is allowing public interest litigation, because if you meet those requirements as an association, you could have a fighting chance. And I think what we can expect is to see a lot more associations kind of taking a stab in the true interest of public interest litigation. So while I agree with disagree with a lot of what Judge Ike said, I do agree with that he said in his dissenting opinion that, you know, what the judgment asserts that it wishes to avoid, it actually has created. So that's one aspect, the public interest, what that means for access to justice in the future. And then just the second thing really quick is to build on what was said earlier about what we can see forward happening in other courts, especially international courts. So I think we will see a bit of cross-fertilization, examples where courts, for example, the ICJ, maybe not the ITLOS because that's coming on the 21st of May, and you know there might not be that much overlap, but for the ICJ, who has been specifically asked to also refer to human rights law, I think we might see some nice cross-fertilization. And I think we might also see some fragmentation because, as was mentioned earlier, there are distinctions that have been drawn with respect to, for example, extraterritoriality. And I think that it's a good sign for future generations as well, specifically because the European Court spoke extensively about that, and the ICJ has been asked specifically about future generations. And in terms of public interest litigation now, the associations having this access, they will be allowed to more openly protect future generations as well. And I think that that's all very positive overall.
Thank you. That's really fascinating. And can I just pick up on that point and maybe ask you to address first this time this idea about whether whether the association having standing and the court enabling public interest litigation in the way that you've described, whether that does amount to essentially an overreach. So you've said ultimately, well, it's a positive thing, you know, we need to protect future generations, and this is a way of bringing the governments, corporations, others to account. But we're also aware, as Richard alluded to earlier, of the significant criticism that the court, as well as the activists who've taken the case, have come under in terms of the court's overreach. So what are your reflections on that?
I think that the court was tasked with something very difficult. I think that we have to understand what the court had tried to do within the wider political context and huge political pressure and climate emergency. And I think that if we look purely at jurisprudence, I would say it could be argued, I'm not completely convinced. It could be argued that, you know, maybe with respect to this new decision on associations, that I wouldn't call it an overreach. That's not the word that I would use. But I do think that there was novelty in what the court decided, that's for sure. But I don't see that as a bad thing. I think that given what, you know, courts have been faced with internationally and domestically, it has forced judges to be creative and it has pushed their boundaries. And I don't think that that's a bad thing. I think that jurisprudence and law evolves. I think that it's getting, bringing judges and courts into the conversation in a positive way. And I think we should expect more courts to, you know, innovate or develop the law in the way that some more conservative people or other people might say that is an overreach. But I think we can expect a lot of that to come before domestic and international courts.
Thank you, Yusra. That's really interesting. Could I invite all of our panelists? We've got 5 minutes left. Could I give you 2 minutes each to address anything else that comes to your mind, whether on overreach or otherwise? And Marc, I've been having a look at the Q&A. The Finch decision has been asked about, particularly with in relation to Scope 3 emissions. Can I put you on the spot and start with you and give you your 2 minutes?
Certainly, yeah. I'll come to that in a second. One of the things that occurred to me, having looked at the role now given to associations, is that I don't see the distinction between climate change and other environmental cases. I have to say, I think that there may be scope for arguing that the court should perhaps extend that standing to NGOs fighting environmental cases, where citizens don't have necessarily the ability to do that on their own. The second point was picking up where Paul left off about evidence that the Agostino case created and is now available for everybody to use, particularly in those 32 member states. One story from the Swiss case was this: on the day of the hearing, we went in to see the president at the beginning of the case and were handed about 90 pages of documentation in German handed in by the Swiss government, which they wanted the court to take into account. It was absolutely outrageous, and it actually, when one had it translated, showed that they were relying on a report from 2012 to justify their position that they had effectively assessed greenhouse gas emissions and the carbon budget. But I mean, just an example of what was going on, as it were, behind the scenes in the Swiss case. And nobody was impressed, least of all, I'm sure, the judges by that. The Agostino case, I would say, pushed the envelope and I think gave us the scope to win in our Swiss case. So I think we were very lucky to have the Agostino case effectively conjoined with ours, so that the court could understand the position of the children and future generations, and indeed interwove that into the judgment in the Klima Seniorian case. So it was a win in my books. From that point alone. As far as fossil fuel development is concerned in the Finch case, which I'm anxiously waiting on in the Supreme Court, I don't think this case, I think the question was, perhaps does this decision undermine the case? Far from it. In my view, if anything, it supports the case that we put in Finch. What we're looking for there is really the decision maker having a duty to take account of the downstream Scope 3 emissions, the exported emissions that effectively will occur when oil is burnt, having been produced in the hills of Surrey, and the same will apply in the Nordic cases that Richard was talking about, and indeed the Oslo District Court in the case that Richard mentioned has recently ruled that those emissions ought to be taken into account by the decision maker. Whether or not that influences the decision maker in such a way that they refuse permission or refuse to grant a license is another matter. But in my view, the court's recognition in the Klima Seniorian case that embedded emissions and downstream emissions are factors that ought to be taken into account by a state when determining its carbon budget, only give us, as it were, more strength in the arguments we put before the Supreme Court in the Finch case.
That's brilliant, Mark. Thank you. Richard, can I turn to you for your 2 minutes?
Sure. And thank you very much. Mark summarized much of what I would have said, so that'll keep me shorter. I think a number of people had raised the question, well, why didn't they go to Article 2? Why did they not deal with that? And I think for the very good reason that they don't want to open the floodgates for each individual applicant or the representatives of deceased applicants to start making thousands and thousands of individual claims to the court. And I think they struck a kind of bargain with themselves. And indeed, that the president herself during the hearing asked the question whether they should, whether we wish to submit that they should be reconsidering their approach to Actio Popularis. And so it was very clearly already in their minds that climate change posed exactly the kind of question that associations, particularly associations with expertise and with financial backing, were in a much better position to address than individual complainants. And therefore, I think it was for that reason, and also to keep things within bounds, that it was much easier for them to go to Article 8 and Article 6 than it was for them to start opening up another can of worms with Article 2. So I think it was a smart move. It wasn't a legal decision that Article 2 could not or would not apply. I'll stop there.
Thank you, Richard. That's absolutely fascinating. Paul, can I lastly turn to you for your 2 minutes?
Yes, I'll try to be even briefer. In the spirit of pushing the envelope, which is, I'm grateful for that characterization of the case. One thing that the court didn't adjudicate upon, because it determined the issue on the basis of admissibility, is the question of shared responsibility between states. I want to emphasize that when I say shared responsibility, I don't mean shared liability. I mean responsibility that arises individually, state per state, but for joint acts. Now, this is a point that has been the subject of interesting and careful consideration, both by the International Law Commission and by an excellent research project at the University of Amsterdam, which published its findings shortly, well, around the same time as we initially filed our case. But the point is that to the extent that it's possible to establish the concept of collective consistency with temperature targets across states, it may well be that shared responsibility between states is a route forward. There's been a reference to fragmentation and a reference to the role of public international law, and this may be something which is squarely within the more traditionally public international law fora. But the court, well, I want to be absolutely clear, didn't reject that proposition in its findings on jurisdiction in Duarte Agostinho. It made a very, very clear distinction between the concept of duty and breach in substance compared to the threshold requirement of jurisdiction. So what I want to highlight and shout about is shared responsibility and see where that goes. Thank you.
Thank you so much, Paul. So much food for thought and so much to digest from these cases. That very sadly brings us to the end of this lunchtime seminar, which has given you a flavour of the amazing work done by all the panelists and the amazing achievements. Can I thank you all for joining us all online and invite you, please, to fill out the feedback form. Once you log off, it should pop up automatically. So thank you very much for joining us again, and many congratulations on your successes, however they look.